We
No,
all
he
moved
wasn't welcome
together.
there, Your Honor, and I have proof of
Tasha,
it if you need it.
stop lying, dude. You gave me the house keys.
Sarah Strout and Joseph Whitaker. Ms. Hively has a personal protection order against Joseph Whitaker, which is file number 25234PP, which prohibits Mr. Whitaker from coming to that address. And that order was issued by Judge Pattison in March. Well, the posture the case is in right now, it's a demand for non-payment of rent, that the rent is delinquent. Mr. Bush has provided me with a accounting sheet, which I greatly appreciate. At this point through August, Mr. Bush, you contend the rent arrearage is $3,000
Yes, Your Honor.
with a $213 in cost, 67 cents, and $120 in late fees through August. The amount is $3,333.67. Is that correct?
Yes, Your Honor.
All right. Ms. Hively, you sent me a letter and set forth the background here, and I'm aware of the circumstances. I also got some other correspondence and some emails, but this is simply a matter of whether the rent is paid or not. At this point, they contend that your rent through August is $3,000, which means it hasn't been paid in June, July, or August. What's your position?
I sent you a copy of the payment history.
Yes.
I do believe it was paid in June. I'm not 100% sure, but
well, you sent me this thing. It shows March, April, May, but doesn't show June.
okay. Well, here's the thing, Your Honor. I'm not opposed to non-payment. That's not where I had asked for a written early termination due to domestic violence because he would not leave the property and nobody was making him leave the property.
Well, it's not the landlord can make him leave the property with a legal action, but they can't just force him out. But theoretically, he was in violation of the PPO, and the sheriff should have been. So are you no longer there?
I left there in March, and then I asked in March, I sent you a screenshot of mine and her conversations where I asked for an early termination due to the events that were taking place and the abuse that was taking place. Because I could no longer stay there and nobody was forcing him out.
All right. Let's talk about this. So are you willing to just relinquish the unit? Do you have all your stuff out?
No, I ended up I went there one day with the police officers. They still wouldn't make him leave even with the PPO order. I don't know why. They didn't give me an explanation. I was able to grab one carload of things and we fled to another state because he was threatening to kill me. But this eviction is going to cause problems for my future because nobody's going to want to rent to me because of his abuse and his choices and his decision. And I didn't have anybody supporting me to get away from him.
All right. So you're out, you're not living there, but all your stuff is still there?
Yeah, I just pretty much washed my hands of the whole situation. I don't want nothing to do with him. He was still there up until I guess the police officers made him leave. Yeah, I just don't want anything to do with that man or my belongings. I can start over. That's fine.
Sir?
Is he there?
Yes, I'm here right now.
All right. Well, you're late to your own party.
No, I've been trying to log in, but it wasn't working. Sir, she has charges.
Well, just a minute. Just a minute. Are you Joseph Whitaker?
I am, sir.
All right. I ask you to take your hat off.
Your Honor, I even have an email from Joseph Whitaker.
Stop. All right, Mr. Whitaker, are you still at this apartment? Now he's frozen. Mr. Whitaker,
Yes,
are you still living there at this address?
I am. Yes.
All right, well, you got to pay the rent. You owe $3,000 in rent, $213 in court costs, and $120 in late fees. So the total amount of rent due is $3,333.67.
I applied for the MDHHS, the SER, the SIR application. I'm just waiting to hear back.
All right. One of the problems is the personal protection order that's in effect prohibits you from being at 219 Venture Boulevard, Apartment 1. So you have a personal protection order in effect that says you're not supposed to live there.
It shouldn't be in effect anymore. I had went in and what is it
still
called?
is, Your Honor.
No, it's not. No, it's not.
I called and made sure from the judge
Stop, Mr. Whitaker. The order is in effect. You don't just call up and ask them to drop it. Judge Patterson ordered
I didn't call. I actually went there. I even tried to serve her. I tried to serve her papers to go to court for that, and she never showed up.
All right. The PPO is in effect. You're not supposed to be living there, but she's not there. So I guess maybe it's not as important. I can't imagine they're going to give you money to pay your rent on a place that you're not supposed to be living at. But the law requires I adjourn this for 7 days.
Okay.
And then I'm going to tell you that you owe $3,333.67 by 10 days from next Friday, which would be 25th. I'm sorry?
That was on her end. I don't know.
Yeah, Miss Hively, what did you want to say?
No, that wasn't me. I'm sorry.
Okay.
I was just
anyway, Miss Hively, you're out of there, so it's less crucial for you because you don't really care. If he doesn't pay the rent, he has to move out, and that's up to him. If
I had to leave. I didn't have a choice. He wouldn't leave. I even have an email from him saying, "Please don't kick me out." That's why he ended up putting his hands on me.
No, I never put her. I never.
Shut up. Stop. This isn't a PPO hearing. It's a non-payment of rent hearing.
Yeah.
And we're quite busy next Friday. 9, 20, 10, 10, 10, 10, 30, 11.
Embarrassing.
John, you're going to have several of these. How about if we continue this to 8:30 on Friday, August 15th? Does that work for you? Oh, that's the first. That's Judge Patterson's pretrial date.
Are you talking the 18th, Your Honor?
Yes, the 15th, Friday the 15th.
Okay, I have one already with you. I have one pretrial right now scheduled early that morning. I think I have something.
Which case do you have with me?
I don't know. I think it's set about
Memory
10:30.
Memory Lane at 10:30. Let's set this for 10:40.
That should work.
August 15th. All right, Miss Hively.
Yes, sir.
You're also welcome to be here. I'm going to tell him that the rent has to be paid or he's subject to being evicted. It's unlikely he's going to get emergency financial assistance for a house he's not supposed to be in. But we'll see where that goes. If the rent is paid, then you get to stay. If the rent is not paid, then he's going to have to move out by August 25th or be subject to being evicted. But we will revisit this entire matter next Friday at 10:40.
Your Honor, can we make inquiry? Where is Sarah Stout, the other defendant?
Yeah, where is Sarah Stout?
I'm here.
All right, who is she?
She's named in the complaint.
Yeah, how are you related to this, Miss Stout?
She was my roommate.
All right, so she's with Natasha.
Your Honor, for a minute, can I say something as well?
Yes.
Sarah moved Joseph in. Joseph is never even on the lease. We rented to Tasha and Sarah.
I didn't move.
I moved in the same time they did.
No, he wasn't welcome there, Your Honor, and I have proof of it if you need it.
Stop lying, dude. You gave me the house key. Stop lying.
All right.
Your Honor, like I said, I have proof if you need it.
Oh, yes, and I do too. God.
Well, let's take a look at the lease. Well, anyway.
I actually moved in before they did, to be honest with you, a week before they did.
Well, you're not on the lease.
Well, I didn't know that.
You're not on the lease, and you're not supposed to be there pursuant to a personal protection order. They're not going to give you any financial assistance to live there. You're not on the lease. So
I went to court for that PP order. I don't know why it's saying it's active.
Go to court. It hasn't been dismissed.
It should have been.
Well, perhaps, but it has not been. He's not on the lease. So I don't know what the deal is, but somebody's got to pay the rent. And Natasha and Sarah are not going to pay it. So my advice to you, Mr. Whitaker, is you find another place to move to, because I'm going to give you 10 days from next Friday to move. They're not going to give you any emergency financial assistance for a property on which you're not on the lease. So, all right, we'll address this further next Friday. That took us
I have a question. This is Natasha. Yes? Is this eviction going to be on my record?
It will be unless we otherwise resolve it.
So, due to no fault of my own and nobody making him leave, it's going to be on my record.
Hey, take responsibility,
I'm going to mute him. Yes. Nobody put you in a relationship with him. I'm not sure what happened, and I don't know why.
No. I wasn't in a relationship with him. I'm trying to tell you. I have an email from him telling him not to kick him out, and I told him he was never welcome there in the first place. Sarah had a relationship with him. Her and I had an agreement. He was not supposed to be there. He was not welcome
there. That's on you guys. But yes, it will go on your record unless it's somehow otherwise resolved. So I'll see you next Friday at 10:40.
Your Honor, do I need to be here too?
Are you Sarah?
Yes, I am Sarah.
Oh, I didn't realize you were. Yes, you're welcome to be there too, Sarah. So you were in the relationship with Joseph?
Yes.
All right, this is even more complicated than I thought. I thought she was. Yes, but as far as I can see, you don't want to come back there anyway. So yes,
no,
you should all come back. All right, thank you. I'll remove you as well. So Sarah was here. She was not properly named. I didn't know who she was. All right, we're off like a herd of turtles. Mr. Whitaker, I'm going to remove you also and send you into the great wide open. Let's bring in Meg Bauer. And somebody named Samsung, which is an actual name. Good morning, Meg.
Good morning, Meg.
Good morning, Judge. Good morning, John. Sorry, I missed.
You missed a lot of fun so far. We had a couple of unruly defendants.
Holding Group Holdings, LLC.
Azara Stafford on behalf of myself and my family.
Okay, where are we on this?
Your Honor, this is our motion to seek distribution of the funds held in the court's escrow account related to this case. Just to recap, two $5,000 payments total, which was the lease payment amount, incidentally, were placed into the account pursuant to the standard escrow order that was entered during the pendency of the case in chief. And then subsequent to the issuance of a judgment of possession, there was an appeal, and Your Honor entered another order, a bond on appeal, under which two additional $5,000 payments were made into the court's escrow account. I've confirmed with the clerk that $20,000 is currently being held. There was an appeal, obviously, hence the appeal bond. That appeal was dismissed by the Washtenaw County Circuit Court. There was a subsequent appeal to the Court of Appeals that was processed as an appeal of right when in fact it should have been otherwise, and that court dismissed the appeal. So there are no pending appeals on this matter, Your Honor. The matter is final and closed. And as an administrative action, I would ask that the court authorize the distribution of those monies to my client. Thank you.
Response.
Well, according to MCR 3.31, this was an injunctive bond that supposed to protect both of us because we counter complained against.
Why was it an It wasn't an injunctive bond.
It should have been because we applied for restraining order against the plaintiff and it wasn't granted. But this plaintiff case still is in pending status with federal court, and we paid $10,000 security deposit. We want them back, and we also paid over $44,000 of expenses that we paid the property taxes, we paid the homeowners insurance, we update and upkeep, and they even charge us attorney fees, Your Honor. And I have the sheet to prove it, and therefore we are entitled to this $20,000.
Why don't we get clear, first of all, what the $20,000 is? The $20,000 was escrow pursuant to the basically summary proceedings action that had been filed. That is not under Section 3 of the court rules. That is actually under Section 4 of the court rules regarding the issuance of an escrow order. I issued that order. You complied, as counsel has indicated, with 2 months of that. Albeit late, there were 2 payments put in. Judgment was rendered. You appealed that judgment. Also pursuant to the court rules, in, again, Chapter 4, you will see that the bond on appeal, I could have set it theoretically at whatever, or whatever bond, but where there has been an escrow order, that escrow order then effectively becomes the bond on appeal. And that's what happened. And so then there were 2 additional payments prior to the dismissal of the appeal that then makes the $20,000. So that we're all, whether we're not on the same, we can all be on the same page or not. That's what happened, and that's why the $20,000 is there. I don't know what you're talking about in terms of injunctive relief. I don't know any of that. That has nothing to do with me in this court. The purpose of that, and the $5,000 was the amount of the lease, basically the lease price of the premises.
Exactly.
All right. You were in possession of the premises up until such time as the writ. I don't know if the writ has been executed or not.
And the return has been filed by the sheriff.
Got it. So you would have had to have paid that amount to be in possession of the premises up until whatever point in time and during appeal. So I'll let you make additional argument, but it seems to me that the $20,000 should be paid over to the plaintiff because of your occupancy of the premises.
Permission to speak, Your Honor?
Go ahead.
What about our security deposit, Your Honor? What about the payment of property taxes and homeowners insurance they forced us to pay in anticipation of the sale? which they breached the contract and they never did, Your Honor.
That would have to be taken up someplace else in terms of the property taxes and whatever. In regard to the security deposit, the security deposit is the disbursement of the security deposit is taken care of pursuant to an entirely different statute.
I beg your pardon?
There's the Security Deposit Act, which governs how that is how that gets returned and or not returned, what it can be applied to. That's not before this court.
Which court is this before, Your Honor?
Pardon?
Which court should I go and ask for return of?
I can't give you legal advice. I'm just saying that issue, I'll put it this way, that issue is not before the court. That has not been raised as the return of the security deposit. Usually is something that takes place after the tenancy. Sometimes it's dealt with during the course of a summary proceedings case, certainly, but that has not been raised here and is not before the court.
I'm raising that today, according to ex parte emergency motion and file, Your Honor.
I don't know that it would be, I don't know that all of the compliance, Gustavo, the act is very specific about certain things that have to happen in order for an issue under the Security Deposit Act to be right to even be heard before the court. I'm not even sure all of that's happened. You can't just say, I need you to deal with this. That's not how it works.
Okay, I petition again, Your Honor.
Well, you can do what you want, Ms. Staffeld. I'm just telling you, I'm not dealing with the security deposit. I'm just not, it's not before me. But the only issue before me is the $20,000 that is an escrow and its disbursement. Is there anything else you want to say?
Thank you for evicting me and my family out of our house, Your Honor. God bless you.
Well, I guess you're welcome. I didn't evict you. You evicted yourself by not complying with the lease. So don't try to put that on the court. Sometimes people, when they have problems in life, have to take the responsibility for their own actions and can't sit there and try to blame the plaintiff or blame the court or blame everybody else in the world. Those are the people that have real problems because they can't take it on themselves to do the right thing. So to the extent I made you realize that, you're welcome. It's the order of the court that $20,000 will be paid to the plaintiff. Counsel for the plaintiff prepare that order so that I can then give that to the clerk and we can disperse that.
Thank you so much, Your Honor. Appreciate your time.
We know this is going to happen, so we are submitting this right now.
Nice day, Judge.
Thank you. They're ready.
Management, like Chase Carlson and Amanda Williams, 24-07290. Counsel, can I have your appearance?
Good morning, Your Honor. Jessica Larson appearing on behalf of the plaintiff.
Is this Amanda Williams?
It is.
Okay, and Mr. Carson, you can remove your hat. This is the court proceeding. Today was the date scheduled for a discovery or a debtor's examination. Were you able to complete your exam?
No, Your Honor. Mr. Carson refused to answer any of my questions. He said he's not going to play games with me.
What games are being played, Mr. Carson?
Well, Your Honor, When I was previously there, I received a verdict by you that I believe to be emotionally charged due to your frustration with my inability to complete the tasks of a lawyer. I attempted to get a lawyer through the system. They denied me. I had to show up last minute unprepared, and things didn't go my way. So I figured, I'll do the process. I'll try to appeal it. I go downstairs and I'm told I have to pay $200 and some to even have a chance to get a fair trial or verdict. I'm having one individual who was emotionally charged at the time decide what has to happen with me instead of a jury of my peers. And now I'm being told I have to produce all my financial statements, documents, vehicles, titles, all this. And I have no interest, time, or energy to continue this charade. I've lost several days of labor.
Let me stop you because I'm just getting updated on this case. This was a landlord-tenant hearing that I presided over. Did you demand a jury trial?
I'm sorry?
Did you make a demand for jury trial in landlord-tenant?
I requested, yes.
You made was there a demand on
in
this?
written? I didn't put anything in writing. I did request the trial. I went downstairs and asked what my rights are, and they said to proceed any further past your decision, I had to pay $200 and some to even try. I did not have the money at the time, nor would I have it.
But sir, I asked you to let me get caught up. I'm trying to see if you have filed a jury demand. Let me also be clear. I don't make decisions because I'm emotionally charged.
No,
don't talk over me. Don't talk over me. Just because I won't let you run my courtroom does not mean that I am emotionally charged. There's order that will be set in the courtroom and you will not talk over people. You will present the evidence. I'm absolutely fair and impartial, and you then have the right to appeal my decision. Just because you disagree with the decision doesn't make it impartial, okay? And if you don't follow, there's rules in place that I don't set as to how you file such appeal. If the clerk's office told you what you needed to file to move forward with the appeal, then that's what you needed to do. But I'm going to make it clear on my record that I did not make a decision in this case based on any emotions. I have no reason to be emotional about your eviction, sir. I'm not being evicted. So if you keep talking over me, this is probably what you did the last time. It's try to cut me off. Yeah, and you're shaking your head. So that's not me being emotionally charged. That's me not allowing you to run my courtroom. You don't talk over people. You have a question.
Yes, I was just speaking and you cut me off, but I'll let I
run the courtroom.
Okay, I understand.
Did you notice that?
May I finish, Your Honor, please?
Yes.
Okay. At the time of the last proceeding, I interrupted you. I apologize. But the second or third interruption, you stopped me in the middle of my sentence and awarded them the decision. You know what? You were like, you know what? Decision for them. You didn't specify why. It was just an emotionally charged because you were frustrated with my inability to complete the tasks of a paid lawyer.
I have evictions every single week, and the majority of my evictions are people who do not have attorneys. I don't know if you know that. Over 75% of our cases do not have attorneys representing them. I do not get frustrated with your inability to do the task of a lawyer. Where I will get frustrated and where I will not tolerate is if you think you're going to yell out or yell at the other party, yell at me, and you're going to act a fool in the courtroom, I will no longer allow you to be heard. Just because I cut you off and make a ruling does not mean that I ruled in their favor because I was frustrated with you. I was going to rule in their favor anyways because of the facts of the case. I was allowing you an opportunity to be heard. But when your opportunity to be heard becomes a hindrance to the procedure in the courtroom, then I have to terminate the hearing. And so if you want to proceed in any other manner, I don't know what your rights are now at this point as it relates to your right to appeal. You may have exhausted that time frame, but you're going to need to appear in person. I'm going to reset this since you refuse to comply with the court order to participate with the discovery proceeding, because this is an official proceeding. This is not your option. You have to participate in the proceeding because you have a judgment against you and the plaintiff has the right to figure out how they can recover on that judgment.
Can we
Do
speak?
you understand that? Yes, you may.
Well, we tried to tell her, like, the funds, we can pay them. Like, we have no problem with that. We tried to tell her the same thing.
What is the past due amount?
It's roughly somewhere in the ballpark of $10,000 with interest, Your Honor.
And
I asked him if they could make a payment in full, and he wanted to argue the merits of the judgment itself. I never heard an indication there would be a payment in full. If there's some sort of payment plan, I'm happy to discuss that once I get my questions answered, because they have made no efforts to make payment on this, never reached out. We've tried multiple different avenues for the information that we did have on where we thought they banked and where we thought they worked. So I would need answers to all of the debtor's exam questions, and then I'm happy to work out a payment plan. In the event of a default, then I can pursue other arrangements.
Okay. Are you in a position to pay in full the past due amount?
I'd prefer a payment plan. I would like to see what the interest is and what the original charges are. I was never actually formally presented with any numbers, despite what she had just told you. Until we were physically served for this court date, I had heard nothing other than a couple of emails where they were denied requests to garnish.
Yeah, we haven't received.
That is literally the only thing pertaining to the case I have seen since I walked out of your courtroom, attempted to file for an appeal, and was told I had to physically come up with money to do so that I didn't have at the time. So I at no point was ever given a fair trial. I was given an opportunity to pay for one potentially, but I've received, like, the judgment is for, you gave them and rewarded them things they shouldn't have had. We weren't there.
If you disagree with the court's position, you have the right to appeal. You failed to do that. I also want to correct the record again. You did not properly file any demand for jury trial, although being advised on your first appearance of how you have the right to a trial and how to file such jury trial demand. You did not file a jury trial demand. So if you didn't get a trial, that was on you.
Then I guess I misunderstood, and that goes back to me not being a lawyer and wishing that I had.
That does not go back to you being a lawyer. We made a video. We make a virtual presentation. It's a video that I play, and every courtroom in this court plays that video at the first appearance. Most of you all don't pay attention to the video. It tells you very clearly in very plain language, you have the right to a jury trial. And you can make such demand for a jury trial, and it tells you how to do that. You don't need to be an attorney to do that.
Sorry, go ahead.
I'm done.
Can she produce an actual number, or are we going off of what she thinks?
So I'm asking for what's in the judgment plus whatever interest is, and I haven't calculated it.
You wouldn't have calculated that before today?
You can do one of two things, sir, because I'm not gonna, the games that are being played, I do not believe are on the part of the plaintiff at this point. You can participate in good faith right now in the debtor's examination, provide the answers to the questions, which are under subpoena. You've been ordered to court for this purpose. Or I can reset this and order you to appear in person. If you fail to do that and to comply, then we have to proceed to a next step, which is a bench warrant. And I don't think you want a bench warrant over a civil matter. So it's in your best interest to comply. It sounds like she's willing to work with an installment payment order, but only after she gets the answers that she needs to figure out how they're going to recover on this debt. So how do you want to proceed?
I'm sorry, Your Honor.
I'm sorry.
I asked him if he had any of the documents there were, in addition to information, there was documents, plenty of documents that were asked for, and he indicated that he wasn't going to produce those. So I would ask him to appear in person with all of the documents.
Oh.
And I'd also ask that, Your Honor, that he return to a tone that is respectful. He has screamed expletives at me the last time we were here in court, and he's called me things today. And it's uncalled for and unnecessary.
I am absolutely clear that the emotional charging was not from the courtroom. I'm not going to allow you to berate anyone in this courtroom, nor will you disrespect me or the process. You can appear in person. I'm going to reset this date, and you need to bring the documents that were ordered under the subpoena. If you fail to comply, the court will issue a bench warrant.
Your Honor, save yourself the time. Have her fax.
Don't tell me what to do. Don't tell me what to say. You instruct yourself.
I'll pay her
You
in
instruct
full.
yourself. You instruct yourself, or you'll be in contempt of court. Okay?
Excuse me?
You control your own mouth. Don't tell me what to say. I've already given you an opportunity.
Your
I'm
Honor.
now resetting this. You can appear in person. If you pay in full, then they can move forward to make sure that this removes off of my docket. But do not tell me what to do. I do not tolerate your tone. This is how we got here the last time. That might work with the lady. That might work with the lady sitting next to you. But you don't talk to me like that. Not in the court, not outside the court. Do you understand that?
I'll pay the balance.
Thank you.
My phone number is on all of the court paperwork. You can give me a call and I'll give you a number.
Give me a new date.
All right, so Ms. Green, it is my understanding that the defendant, Royal Palms, has gotten a judgment against you in magistrate court, and you are here because you are appealing that judgment. Is that correct?
Yes, Your Honor.
All right, 1 second. Let me
May I say thank you for taking the time to hear this case. It's very important to me, and I'm honored to be among your presence this afternoon.
No problem, Ms. Green. It's kind of what I do. So let's see what we can do. Let me find the bench brief so I can go back to the procedural history on this.
Judge, can you take just a moment to meet me in a breakout room?
Yeah, hold on a second. One second, Miss Green, Mr. Green. I'll be right back. All right, Mr. Green, I have a question. So Royal Palms Inn, is this like an extended stay or is this an apartment complex? Mr. Green, can you hear me? Can anybody hear me?
Okay.
Mr. Daniel Green?
This is Cecilia.
Yes,
No.
my client, Mr.
Mr. Green, your audio is horrible.
Are you there? I know.
Who might tell because they need to mute. I can hear feedback. Yeah, Mr. Green.
This is Pastor Cecilia Green.
Mr. Daniel Green, Mr. Patel, Mr. Patel, I need to see you, and I need y'all to.
No, Judge.
Okay, that's better, Mr. Green, much better. I can hear you much better. So you can get rid of the one that's not working. Yeah, that's better.
Just look over the brief again.
All right.
Just give me 1 second. So, Judge, this is my client is on. His name's Mike Patel. Mr. Patel, can you hear me?
Yes, I can hear you.
Okay, could you answer the judge's question for me?
All right, Mr. Patel, can I see you?
I don't know. It's all.
Hold on. Yeah, are you on your phone?
No, I'm on the computer.
Don't see a video option. All right, so Mr. Green, is this an extended stay or is it an apartment complex?
No, this is not extended stay or apartment complex. This is a hotel. Daily rental. Right.
All right, and how long is the longest rental period?
We don't have a time frame. Tenant can stay as long as they pay the rent.
Okay, and how do they pay? Like, do they pay daily, weekly?
Only daily. No weekly, no monthly. We rent only on daily basis.
Okay. All right. 1 second. Miss Powell, print out the magistrate court judgment for me, please. Okay, so Miss Green, when did you start staying at the Royal Palms Inn?
Unfortunately, it was right during the COVID area when I I and my son was, I have two sons. I and my youngest son was put in a precarious position as to where we were homeless and didn't have anywhere to go. And some of my my church brothers and sisters helped me to find a place. It wasn't every day at the start. It was whenever we could afford it. We did sleep in a lot of people's houses that we didn't know. And unfortunately, we had to stay in the car for one night.
Okay, how old is your son?
My youngest son is 27, and he basically paid 90% of whatever he got came from my son's paycheck. Your Honor, I would like to add something else if I could pertaining to this.
Sure.
It's so obvious that we have been dealt a really bad hand. And the reason why I'm saying that is because when Mr. Patel came over here on October the 31st and filed this hideous, I don't know what you want to call it, against us, he just didn't start out right. He didn't tell the truth about why he came over here. And I think it's really sad. If you're going to bring something like this against somebody, don't just tell your part of it, tell it all. And he left out a whole lot the day that he came over here on October the 31st and did this. And for me, it was embarrassing. It was embarrassing, to be honest with you. I'm not in here.
Miss Green,
Yes.
hold on a second, because this is a little bit. I know people are struggling, but you have two grown-ups. Your son is working, but y'all have been in a hotel, not an extended stay, but just a daily hotel since COVID. That would have been like 2020, 2021, and y'all haven't moved forward from there. So let's talk about kind of the limits of how long you can stay in a hotel and what issues occurred such that an eviction was issued at the lower level. Okay.
This is why we were there, because we had actually been in a homeless state. It's not,
I got that.
Not something I'm proud of, but we were seeking shelter wherever we could find shelter. And like I said, we stayed in a lot of people's houses that we didn't even know, between Rockdale County and Henry County and Clayton County. And so we were just looking for something, because I could not work and I only had a SSI income, which was not very much. And my son had a full-time job. And so he was able to carry the load while I was in this position of looking for somewhere to go. Now, we did apply in a lot of apartments in the vicinity, but because I didn't have a good income, along with my son's income, we were denied. That was 3 apartment buildings, I guess in the vicinity over there, and we tried and we were actually denied because of my income situation.
Okay.
I want to elaborate on why he came here, Your Honor. He came here.
No, I'm going to object to this, just going into, if I may.
Hold on, Mr. Green, because I'm trying to get the procedural history. I'm waiting for Mr. I'm looking. I understand that the dispossessory was initiated. There was an answer filed. Judgment was granted. The judgment was appealed and costs were paid. The issue that I have is that I don't have the printout for some reason.
Oh, I got you. I understand. I just
that's
thought
what I'm looking at.
Right. So when she started testifying about why my client came to file, I just want to object. Thank you.
Yeah, Mr. Green, Miss Green, hold on just a second, because I need to know what happened below before we can move forward up here. That's it. Okay. All right, Miss. Oh, thank you. Maybe it's in this stat. Maybe I mixed it up. Okay, so what was the basis of Mr. Patel filing for eviction? Was it non-payment?
Correct.
Okay.
I'm sorry, Judge. I just sent you a message. I was looking in the wrong place. I do have.
Yeah. Thank you. Because I got the other stuff, but this is not helping me understand what happened below.
Your Honor,
Yes.
we're paying until my son's job was taken overnight, and we were paying really good until Mr. Patel scammed my son out of almost $4,000 using aliases called Cash App Taylor Sugar Mama.
Okay. Hold on.
That's how this came out.
Hold on, Miss Green. Hold on.
Just tell it all.
Miss Green, hold on. I need to know what happened below before I can move forward with this, okay?
Thank you, Your Honor.
All right. So, Mr. Green, what is the amount of the non-payment?
Through today's date, Judge?
Yeah, that's fine.
I'm showing a balance of $9,653.05.
Your Honor, that's correct.
Hold on, Miss Green. Hold on. I'm gonna give you the opportunity to tell me everything you need to tell me. I just need to know how much is charged, how much they're asking for, what the magistrate court knew. Okay, what is the daily rate?
Your Honor, the daily rate is $69.95.
Okay, and how many days overdue is she?
Oh, a lot, Your Honor. This dates back. And Mr. Patel, do you happen to know the last day that you received a payment?
Yes.
It might be back in was it February 2021?
When did she start paying, you mean?
When was the last day you received a payment?
That was in October 2024, October 2025.
Come in.
Okay.
For September's rent.
Okay, thank you.
Okay, because what he's asking for on October 31st of 2024 was $2,308.30 for possession of the premises, and then it does list $69.95. So since October of 31st of 2024, we've gotten $6,000 more dollars.
Yeah, Judge, because it's $69.95 a day, which equates to approximately $2,168.45 a month. So I'm not great at math, Judge, but
okay,
that's about $6,500 already added to what she already knew. So that's how we got to around the 9,000.
Okay, all right. Now, Miss Green, tell me what your appeal is based on, because the court granted possession and judgment against you. What is your appeal based on? Oh, before you start, let me tell you, there's only certain things that I can consider based on the law. But one of the things that a lot of people who are in a tenant position don't understand is that if you are in possession of the property, meaning if you are still living in the property, you have to pay the rent. Hardship is not an excuse. I don't have the money is not an excuse. You have to pay the rent. If you cannot pay the rent, then they're entitled to that. Even if there are things that they need to fix or repair, you still have to pay the rent. You can ask for a deduction or an offset, but you still have to pay the rent. So as long as you're in the property, the landlord is entitled under Georgia law, they're entitled to have the rent paid. So now tell me what's going on that you now owe $9,653.05.
Your Honor, when I went in on a Friday, 1/1/1/24, that's 11-1-24, to pay what I could pay based on my son's part-time salary, these are the words that I heard, and I'm quoting: "The process have already begun. I can no longer take any payments from you. I have filed a petition against you. Your Honor.
That is correct. Under the law, Ms. Green, Ms.
Yes.
Green, he filed on October 31st. Under the law, he cannot take any money after he is filed for eviction because that would invalidate the eviction. So he is legally correct. On November 1st of 2024, he could not accept any money if he still wants possession of the property and he wants to come before the court. So that is correct.
Okay, can I proceed, Your Honor?
Sure.
So when I went in, I asked him to take whatever we could, regardless of what he had already done. And his thing was, I cannot accept any money anymore.
And he's correct.
Well, what do you expect me to do? He turned me down. He did not accept anything from us. I wasn't gonna go over there every day and
no, ma'am. At that point, Ms. Green, you have an option. You have the option to leave, or to pay the entire amount. If he won't take the amount that's owed, then you have the option to leave. But he's under no legal obligation to take less than what he is owed. If he says that it's $69 a day and you don't pay $69 a day, and I get it, your son has a part-time job and you're on SSI, but if you don't pay $69 a day, he can file for an eviction and the court can hear it and they can rule on it. You haven't given me a legal basis for why you should still be in this man's property.
Your Honor.
No, yes, ma'am.
He has committed so many crimes against.
I'm going to object to this, Judge.
Mr. Green, you can object all you want. Miss Green, if it is a crime, if there's something criminal that happened, you need to march down to the police station and file a police report or take out a warrant. If the police are not willing to pursue it, the matter criminally, you have the right as a citizen to attend a warrant hearing and have a judge determine whether you as a private citizen can bring a criminal warrant. But that has nothing to do with evictions.
That is exactly what I did on the morning of 11/1. I went to the Clayton County Police Department.
Okay, that's not anything criminal. That's not going to be relevant.
I know, but I'm just telling you, you just mentioned, I think I heard that right, correct me if I'm wrong, that I should have went down and filed a report against.
No, I said that is something you can do. I'm not telling you to do it or not do it.
I did it.
What I'm saying to you is you have not given me yet a legal reason why Mr. Patel is not entitled to have his property and his judgment.
Your Honor, he wouldn't take any money, and I didn't know.
Ms. Green, I have told you before, he's not required under the law. It would be wrong for him to take money after he files. He filed on October 31st. The very next day, he cannot take money.
So what am I supposed to do when I
Leave.
have the money, ma'am?
You don't have all of the money. Do you have $9,653?
The day that I went in to pay him, I had got some help from other people, and he said he wouldn't take it.
Okay,
and
because
now he wouldn't take it. What am I supposed to do? It accumulated because he would not take anything.
Miss Green, Miss Green, just let me be honest with you, ma'am. What he really wants is you out. He wants you out.
But
he's entitled to that.
You know what's really sad? He committed all these crimes against us, and now he wants
to object to that, Judge.
And that's fine, but that's a separate thing. That's not something that we can handle here. You're not going to address the crimes by staying in his property.
I have already addressed the crimes. I went to.
Okay, then staying in his property is not going to address the crimes. I need you. I'm going to give you one more opportunity to give me any legal reason why I should not affirm the decision of the magistrate court.
Because I have nowhere to go. This man.
Okay, that's not a legal reason.
Okay, well, I'm gonna say it like this: what he did to us, what he has put us through, is criminal, and it's a sad day when it seems like crimes are okay for some people and not all right for others. He has been eavesdropping on all of my phone conversations for 4 years.
I'm going to object to this.
I don't even have peace anymore on my phone.
Miss Green, let me tell you, ma'am, the option is to leave. He controls the building. I can't
Where
say
do you
where
go when you don't
Miss
when you
Green.
don't have nowhere to go? Where do you
I'm
go?
not sure, Miss Green, and it breaks my heart. But let me just tell you, there are people in tough situations on both sides. If you think about it, you're saying, let me stay here because I don't have any place to go. But what you're doing is denying Mr. Patel money that should be going into his business or to his family because you're saying, I'm going to just stay in. No, listen to me.
What about what he scammed from us, ma'am?
Listen to me. You're saying, I deserve to stay here because I don't have any place to go, but you're denying the fact that he bought this business to make money and to support himself and his family. And you're denying him that money because you don't have any place to go. That's not it. You are responsible for yourself. Your grown son is responsible for himself. You are not Mr. Patel's responsibility. You are not. And as heartbroken as I am that you are in the situation that you're in, that is not Mr. Patel's responsibility. If you believe he's done something wrong or criminal, you have avenues for that. You can sue civilly, you can go and pursue criminal matters, but this is not the way you address that. So at this time, because you have not given me anything that shows you have a legal right to possess the property, at this time, the court is going to grant Mr. Patel the $9,653.05 of the judgment that he obtained from magistrate court. I'm going to affirm that judgment, and I'm also going to give him a writ of possession for 7 days from today. Okay, so you'll have 7 days to vacate the property.
He scammed us out of money, and that's one of the reasons why we couldn't.
Miss Green, unmute, officer. Let me hear her. Miss Green, I'm sorry for the situation you are in, but ma'am, that's not Mr. Patel's responsibility.
Yes,
and if
us, ma'am,
then you go to the police and pursue a criminal action.
I've done that. I have a case number 240.
That's fine.
6962.
I've
done that. Yes.
Okay, but that doesn't mean you get to stay in his property.
Ma'am, we have been taking so much from this man. It seems like he's getting away with all these crimes and nobody seems to care about what it has impacted our household income and why we couldn't pay to stay over there because he took so much from us from the get-go. He's done this in the broad daylight, ma'am. I'm not lying to you.
I'm not saying that you are, Ms. Green. What I'm saying to you is in the context of an eviction, those are not things I can consider. What I can consider is you have not given me a legal reason for you to stay in the property.
He took from us and we couldn't pay him anymore.
Okay, so unmute, please. I know she's talking, but that's okay. So, Ms. Green, unfortunately, the court is going to have to affirm the decision of the magistrate court. I'm going to issue the writ of possession. You'll have 7 days to vacate. If you are not out in 7 days, then the sheriff will be able to execute the writ. All right, Mr. Green, do you have an order?
Your Honor, I will get an order to, who would you like me to email the proposed order?
Ms. Collins.
Yes, Judge. And then, Judge, if I may, I don't know if you want me to wait, but I need to address another case with you. I think I made a big grave mistake. I thought this case was on this calendar, and it looks like it might have been on your 11 o'clock calendar.
Yeah, probably.
Yeah.
Which calendar is that?
Judge, it was Velocity Investments versus Charmaine Page. I thought it was. I put it with my files today. I've been going.
Miss Payne, she was here.
Okay, I've been going through chemotherapy treatments, Judge, and I had a recent one last week, and I was putting all my files together, and I put this one behind that one.
Okay, well, you can move the court for reconsideration of its order.
Did you already issue that one, Judge?
I did.
Okay, I'll get that filed.
All righty, and I'm hoping and praying.
Ms. Powell, can you put your email in the chat for me, please?
Yes, Ms. Powell. Ms. Powell, if you'll chat your email to Mr. Green. All right.
Once I receive that email, Judge, may we be excused?
Certainly. Ms. Powell,
Thank you.
I just added it to you directly, Mr. Green.
I got it. Thank you.
All right, and I hope everything goes well for you, Mr. Green.
Thank you, Judge. Good to see you.
All right, good to see you too. All righty, thank you all. This concludes the calendar. The courtroom is down. Thank you, deputies.